Any mention?
Yes.
Any mention?
Please, Your Lordship, I beg to mention item number 29. Item number 29. Conducting counsel is out of station.
No objection, Your Lordship.
Your Lordship, similar prayer for item number 30.
When? Tomorrow?
No, sir, after 1 week, Your Lordship.
1 week?
Yes, sir.
And number?
30, Your Lordship.
Yes.
Obliged.
Supplementary list item number 1.
May it please your Lordship. Lordship, this is a land compensation matter. The petitioner is the owner of a plot of land at Maran Somalang, which is at Mairang, East and West Khasi Hills district. Lordship, the land was purchased by way of a sale deed dating way back to 1954 by the ancestors
1954?
of the... Yes, Lordship. It was purchased since long time. Since that time, Lordship, 1954. The original sale deed is at annexure number 2 at page 14. Now what happened, Lordship, is that...
This is a sale deed?
Yes, Lordship, that is the Kacha sale deed. And the same
stamp paper?
Yes, Lordship, and the same was registered before the CM of Himanong Klau, which is annexure 3, page 26.
This is, when was it bought? 54?
54, Lordship.
And then?
And the same was registered with the CM of Himanong Klau at annexure number 2, which is, number 3, which is at page number 26. Now, what happened in this case, Lordship, is that the land was identified for acquisition for transmission of a 220 kV power lines. And what happened, Lordship, is that the CM of Himanong Klau had taken away the land and approached the respondent number 5 to identify his
taken
land.
away the land?
Yes, Lordship. So what happened, Lordship, is that the respondent number 5, which is the CM, the respondent number 6, which is the CM of Himanong Klau, had purported and projected itself to be the owner of this particular plot of land and had approached the respondent number 5, which is the district council, to pass an order in their favor, which is at annexure number 9, which is at page number 56, Lordship.
Page number?
Page number 56. Recognizing them as the lawful owners of the land.
Since 22?
Yes, Lordship, 2022. Now, what is
this? You're a complainant there?
Yes, Lordship.
You're a complainant here?
Yes, Lordship.
You appeared for this also?
Yes, Lordship. We had appeared. We had filed our objections as well, Lordship.
You put this order to challenge?
No, Lordship. That was Lordship. What had happened is that the district magistrate had called for a hearing as well, Lordship, and the
no. What see? Petition file so. One petition. Who trimmed it? Mary Wargery.
Lordship.
Who's this? See the first part. Who trimmed it? Mary Wargery. Is a predecessor in interest?
Yes, Lordship. It is one of the.
Then.
So what happened, Lordship? We were not privy to this order as well, Lordship, and then we were called for hearing.
If you were part of proceedings, how come you were privy?
We were not.
Totally found. You should have.
Yes,
what
Lordship.
happened to the proceedings?
We were not aware of the order which was passed, Lordship. So what had happened is that the district magistrate had called for a hearing to ascertain who was the owner of the land, and we had filed our objections then as well, Lordship, which is at annexure number 7, page number 58. Now what had happened here, Lordship, if we go to page, if I may take Lordship to page number 59, the first paragraph, the rightful owner of the land in question shall be determined in due course of time by the competent authority. Meanwhile, the power grid shall estimate so and so for land.
What happened after that?
So what happened after that, Lordship, is that we were awaiting any sort of correspondence between us and the district collector. So but nothing had happened. Then sometime in the year 2025, Lordship, towards the end, we found out through reliable sources that the money had been disbursed. And so we had preferred an RTI and found out that money had actually been disbursed to the respondent number 6, which is the CM of Himanong Klau.
So, see, Mr. Aim, how can you sustain this petition then?
Lordship, my prayer is very limited, Lordship,
Firstly,
in
it
this.
stems from title.
Yes, Lordship.
Next, now you want recovery of money.
Yes,
Then
Lordship. Lordship, as per
what
section.
does the court do?
Lordship, I am before your Lordship on very limited prayers, Lordship. As per section 16, the district magistrate or the DC is not a competent authority. He is an administrative head, and the matter should have been referred. He
Where
should
the
not have.
order is, where the district magistrate declared that, whoever, one number 6.
Yes, Lordship. We do not have that order, Lordship. As per the annexure number 7, which is at page number 58.
Now this 57, what is this?
Page 57 is the minutes of the meeting, Lordship. We were waiting for correspondence, Lordship, but we did not receive any orders.
From this document?
Lordship, this was given to us. This was given to us long time back, Lordship. After it was sent to.
They do not want any wine shop in the area. Regarding the matter of shop, already given permission as per norms, the locality and the church leaders stated that there is a requirement of taking public opinion into consideration, and that public opinion was clearly not in favor of the shop, and all the people in that area are vehemently against the opening of the shop. The excess officer were asked to how the people were invited in the original meeting to take public opinion for shifting the shop, to which they replied that the original meeting was called do Nokma of the Danakri, under whose jurisdiction the shop for. Now, Your Lordship, this is very important, which I am going to do. The representative of the Tura Municipal Board, Tura, has clarified that Walbakri locality does not fall under the municipal area, and therefore it is not under the jurisdiction of any development committee. The shop is approximately 200 meters away from Tura Town Church and Nexengitum, the church and the nearest educational institution, and at least 300 meters away from the nearest development committee. The Walbakri Development Committee, whose members are present in the meeting, are complaining against the shop. Now, regarding the question of bootlegging being rampant in the area, the complainant acknowledged the problem. Addressing the matter, the superintendent of police, Tura, also said that in the area of existing location of the wine shop, complainant has been reported for many bootlegging business in the area, and asked the locality leaders to give written complaint against the illegal business for police to take action on the illegal selling and the shop black market in and around the adjoining area. The chairman also suggested that reopening of legal wine shop can control illegal selling of liquor. However, the complainant still stood their ground that they do not want any wine shop in the area. Now, another is very important, my lord. There is they have reported regarding another existing shop burden. Regarding the question of another IMFL on shop present in the area just 105 meters from the wine shop in question, the locality member claimed that the restoration cum bar was opened with the blessing and prayer of the church. So they are saying that since they are not taking action against the another shop which is the existing
one shop, they don't want your
they
shop.
don't want to open because
shop,
it was blessing and prayer. Blessing was there. Then in that case, I also can invite some Patar Pamong or any church leader. They can bless. Then I should be allowed. And then this action, and then there is no complaint action against.
Mr. Shlai,
Lordship.
you see, the thing is that what's important, just apart that, see, the thing is that as per the Excise Act now, this 200 meters away from at least 100 meters away from nearest development committee is also what do you call it, education institution 7 meters away.
Lordship, yes.
Then, and it's not even in the Tura Municipal Board.
Lordship, their fag is done. They have the valid license and all.
So can you stop? Of course, trading in liquor is not a right; it's a privilege that's given by the state.
The only thing
but
that
whether the privilege has been given to them can be taken away by other people. Because if we understand, if there's no, wine stores, anything in the area now, another one's just 105 meters away and with the locality.
another one, as per this report, yes, Your Lordship.
You make them party. Who's this person to here? You impede them, let them come here.
Lordship.
I will file an application. However, Your Lordship, at this meantime, because it is very clear from the municipal board that they have no jurisdiction to file a complaint. Also, it says. So
The thing is that just objection
because right now, if the petitioner is allowed to run, Your Lordship, because it appears, Your Lordship, from the report.
But in the other shop, they are allowed to open the state respondent have nothing to
one
do.
thing also you must realize is for public interest, right?
Lordship,
For public health. It is public health. Now the thing is that if it is a fact stated here that if if a wine store always it stops illegal sale wherever there's prohibition or then it encourages all this black marketing, bootlegging, and it's very harmful for public health.
Lordship, from the report, it appears, Your Lordship, that one shop is there, Your Lordship. They have no problem, and for the petitioner, they have the problem.
Lordship, I make a small submission that I will undertake. The moment if there is any objection or any law and order problem, I will immediately close this.
But they've already objected. Who are the objectors from the list of these people? Let us see. Who are they from the list of attendees?
3, 4, 5, Your Lordship. Lordship, kindly have that
3, 4, 5 is
a copy if Lordship is having the report.
No, 3, 4, 5 is executive engineer. 4 is enforcement inspector. 5 is church elder of this church.
Yes.
Then this 5 who is only one.
Yes,
Who's the one who spoke in the meeting? You were there.
S.R. Sangma, Your Lordship. Then Reverend Jack
No,
and
number 5.
Number 5 is
Number
Jack
5
and Sang Pastor.
the President's Secretary Walbakri.
Then Jack and Sangma,
Development.
pastor, what's his? Tura Town Church. Then
6 is the Nokma.
No, Nokma actually has no complaint. Actually,
6 the petitioner, Your Lordship.
6. No.
3, 4, 5. Let them
3,
be
4, 5
impeded.
is executive engineer.
Yes.
The Tura Municipal Board, they're not important. Now only church elders, that's number 5
Number 5.
and number 10.
Number 5 and 4.
11.
He has given the unsigned copy.
Not
Lordship,
4.
Lordship is having mostly a wrong copy, Your Lordship.
Because our copy is major copy.
It is members present meeting discuss issues pertaining to grant of CC. 19 March 2026.
Lordship, kindly have our copy, Your Lordship. Lordship, kindly come to the page, internal page 3, Your Lordship. Lordship, 3, 4, 5.
Page 3.
Internal page 3, Your Lordship, of that.
Same copy.
You give me a wrong copy.
It's the same.
There's no list here.
Copy 2 is there.
Copy, Your Lordship, copy 2. Copy for information unnecessary 2.
Those are the parties.
These are the people who were
Page
present, Your Lordship.
Page 3.
These are the main, it appears, Your Lordship, these are the main people.
Copy for information and selection. They have given serial till 8.
3, 4, 5, Your Lordship. Yeah, the people present in the meeting. Yeah. We have the attendance sheet.
This one.
So 300 meters away from number 5. There's 200 meters away from number 4. And 200 meters away from both this Tura Town Church and Nexigittam.
Then 105
Allow
meter.
you to take law into their own hands also. If they were just opening it illegally, you can understand. Yes, this take down. Pursuant to the order dated 2/03/2026, a meeting had been convened by the Deputy Commissioner with Garvils, wherein all interested parties were present and I had taken part. I had participated. So, a perusal of the minutes of the meeting held on 19 March 2025 reflect that the objections of the persons, namely the pastor of Nixon Githam Baptist Church, pastor in charge Pura Town Church, and the present secretary of the Walbagari Development Committee. Well, only that they do not want a wine shop in the area. Stop. The findings of the inquiry show that the location of the shop is 200 meters away from the Surah Town Church and Nexigitum Church, and also the nearest education institution is at least 300 meters away from the nearest development committee of the Walpagiri Development Committee. The excise act says how many meters? 150?
150 actually.
150 meters away from any educational or church.
Lordship, yes. 150, I am not mistaken. It's there also.
Just see the excise act. It's 150 meters or 200.
Check the excise act. No, from the mobile. From the mobile? No, it's not there.
Section 119. I got local act. Look at like
See rule 183. 183.
There's a compilation. Yes, sir. Just see it, section 119.
Lordship, let come tomorrow. I'll just have a look at that distance, your Lordship.
Okay, we just
Come tomorrow, your Lordship.
Report. The London AG has submitted the minutes of the meeting held pursuant to order dated 2/3/2026 with regard to the wine store of the petitioner. Submit tomorrow for further orders. Yes.
Lordship, yes. Apply, your Lordship.
You come with the come with the act if you want some relief. Otherwise,
you ask from the distance.
I don't know why we don't have it here. Even act.
Apply.
Lordship.
Yes, Dr. Zika.
My lord, in item number 8, affidavit in opposition has not yet filed, my lord.
8 to 12 are connected matters, my lord. They are fresh matters, my lord.
3 weeks.
8 to 12 and
13
to 16
Or ACR
pertains
matters.
to non-communication of ACR, my lord.
Same, yes.
I'm praying for some more time, my lord.
Same is order.
We'll get the
8
facts.
to 12 different and 9 to
13 to 16 are ACR matters.
13 to 16 ACR.
My lord.
So we can dispose them of
Only
if they are situated in the same circumstances.
Only
My
few
lord,
facts,
this is
my lord, for
covered
which year is not coming.
Yes. This is 9 to 8, 12 disability.
Lump sum, yes.
Yes, my lord.
8 to
12 disabled.
What about the Supreme Court judgment about disability that came recently? Or is that judgment
My
Delhi?
lord.
This is just recent judgment.
I've not come. Delhi High Court.
Delhi High Court, I think.
I'll check that.
My lord. Dear your lordship.
That is come.
17.
Yes.
For affidavits, but
You take notice on CISF.
Yes, ma'am.
Dr. Musika will also, Dr. Emre led DSGI with MS Emre Chang will also be
That's one number 4. Yes, go ahead.
will also represent one before. Such no further notice necessary. Senior counsel praise funds allowed.
2 weeks.
2 weeks time to file applications.
18.
Obliged.
May it please, Your Lordship. We want at least 2 weeks' time, Your Lordship. We've just received instructions to file
What's the matter
affidavit.
about Mr. Sangma?
Regarding their honorable acquittal.
They want reinstatement after the criminal proceeding.
Police.
Police. Yeah.
He was in the police department.
He was in the
Police department, Your Lordship.
It is
He
a
was dismissed from
second round of
service.
litigation.
yes, MS T. Yangi. The praise for and allowed for the 2 weeks time to file applications.
19.
Yes.
May it please your lordship, my instructions in this matter are not complete. I've received instructions from the respondent number 3, which is the Tadlasken Institute of Education and Training. My instructions include the breakdown that they are seeking in terms of the owings to the petitioner. Once I file that affidavit, lordship, I think nothing would be left in this matter, although I'm still waiting for instructions from respondent number 2, the directorate. And I just want to see that there's no conflict in what I've
Yes,
received from
215.
Yes, 415, you know. We won't file in the
You won't find the affidavit. You are Mr.
P. Karsimli.
P. Assembly. Yes, sir. Ms. ESD has submitted that praise that for the 2 weeks time be allowed to complete the instructions to file affidavit praise allowed. Mr. P. Assembly
Yes, Your Lordship.
of 15 submits that no affidavit before come to respond. This after 2 weeks.
Obliged.
20.
It's been this case, I'm yet to receive Paravai's comment. I may be given 2 weeks time to file my counter, Your
No one
Lordship.
appeared last time.
Sorry, my apology, Your Lordship.
You're tired of this job now.
It's not. I got.
Yes. What's the matter about?
This is pension matter, Lordship. Here, Lordship,
Where's E.B. Pasa? Not here also. Mr. H. Abraham is present. We have someone in 8 today. And says that when was the matter filed?
It was in month of
For the 2
February.
weeks time we allowed for affidavit. Sprays allowed. There's no appearance. We have respondent number 8. Number 9.
my lord, here my lord has passed one judgment. I am relying that judgment only because this
Let
is
them
over.
file
Yes,
affidavit.
yes. Let them file affidavit. Yes.
Kindly update, Your Lordship.
2 weeks.
21. Your Lordship, here also it brings 2
Lordship,
weeks time. Your
there is an
Lordship.
order, Your Lordship, on the last occasion, we want to report to the order dated 16/2/2026, where I have praised for the interim, Your Lordship, because this is the case where actually, as per the NCT norm, the 45% is required for mandatory for the appointment as a pre-necessary. This one, there is an order also, Your Lordship. I will just take you to the.
You are supposed to obtain instructions.
We've
Not by affidavit,
obtained,
Lordship.
no, we've obtained instructions, Your Lordship. It shows that the petitioner had got
I'm
49%, 49% in class
point
12.
four.
And the respondent number 4, I don't know if she has
No, she
received.
has not even reached 40% also.
Then what happened?
So, Your Lordship, but then the instructions tells us that just because she has got 49% in class 12, that doesn't confer any automatic right on her to.
No, but did the other respondent before?
There is respondent
Pass the
number 4
qualifying
has.
No, he don't have the
She has
qualification.
got less than 45, Your
Then
Lordship.
she was appointed.
She was appointed, Lordship, because the overall assessment from all aspects, Your Lordship, shows that she is better than the petitioner, Your Lordship.
No, but if it's a requirement that they obtain 45% in their, what is this in there?
In that
NCT.
yes, NCT also the director of
says that.
director of school education also have
So,
issued.
Your Lordship, let me file an affidavit, Your Lordship,
Then
and
we
we
should-
can hear the matter.
If the instructions are, we can dispose it of now.
The instructions are
Lordship.
quite sketchy, Your Lordship, so we have
Page
to stay.
page 20 annexure 2 also, Lordship, the
Where's the
director of
impugn
school
order?
education literacy
Yes,
has
yes, where's the impugn order?
that impugn order actually. I don't have the appointment order, but the result declared that that impugn order 43 page 43. That is the main my main challenge 43. This is the
The
result
result
declared.
of personal interview dated 20th.
Actually, he was not even qualified to be accepted. His application should have been rejected out of pride because he has not even got the minimum qualification to even for application. This is the I'm challenging this one. So I want to
She
stay
was
this
recommended by
impeachment
the
order.
interview board, Your Lordship.
When the law is very clear.
Yes, take down. MST Yangi today has prayed for further time to file affidavit. How he submits that she is in receipt of instructions, and that from instructions
Petitioner has obtained 40.
the petitioner
Has obtained
had
49%.
obtained 49%, whereas the
Whereas
respondent
she's less than 45. Your
less than
Lordship.
45%, which does not meet the NCTE norms. However, she submits the appointment was based on her overall performance.
Overall performance in the interview.
This court, though, noting submissions made by Lund AAG, however, as it is Paramphasai, seen that the respondent before, who was, have you taken steps?
Yes, I have taken step. They have received the notice also, Your Lordship.
Was not present today, did not have the qualifying marks. The continuous appointment shall be subject to the outcome of the
Outcome
petition.
of the case.
Lordship.
This after 2 weeks for
2 weeks,
affidavit and for appearance of respondent before.
Lordship.
Obliged.
Much
Your
blessed, Lordship.
22.
So she's already working or she's been appointed?
I think her appointment was approved, Your Lordship.
But has she been appointed or not?
Appointed? Yeah, she's been appointed.
Appointed? Sure.
Approval was given by the
The
government.
affidavit comes later on and she's appointed after the orders of this court were passed.
Apparently, she's already joined also, Your Lordship. That's my instruction, Your Lordship.
Yeah.
Obliged.
22.
Lordship, in this matter, I think state he has to file, is to get the supposed to get instruction, Lordship. My learned friend is appearing. This is regarding pension, my lord.
Question matters,
Yes.
no delay. Yes.
May it please your lordship, this is regularization, I think.
No, he was already been regularized. And then now is only for pension. He was retired on 2016. After retirement, his service has been regularized. It is there, Lordship. I have annexure 3.
File affidavit. Otherwise, you can just
Please, lordship.
Lordship.
as place for the 2 weeks time allowed affidavit.
Grateful.
Much blessed, Lordship.
23.
My lord, I'm praying for some more time to file my affidavit, my lord.
Yes. What's the matter about?
This is the matter, my lord, where they are asking for some allotment, stall allotment. Whereas till now, my lord, we have not given anyone, my lord, till now.
Where?
In Laibukla, my lord. So we are praying for some more time, and we are also examining, my lord, whether he is entitled.
Oh, you're
or
an
not.
old leaseholder.
Yes, Your Lordship. We are
He is an old leaseholder, so they are just examining it, my lord. So I'll file my affidavit. I'm praying for 3 weeks time, and positively we'll file it within 3 weeks, my lord.
You mean a new supermarket?
Yes,
Your Lordship.
yes.
How many shops are there?
I don't know exact number, my lord, but
If you have the instruction, you should know.
I will
You're a
take
council of
instruction.
Muda.
yes, my lord. I will get it. So it is under municipal, my lord, not under Muda.
Same thing, Municipal
Yes,
Muda,
yes.
same thing, Municipal
I will take
Muda.
instruction on this one.
Yes, Mr. SD, counsel for respondent number
2, my lord.
to praise funds allowed further, 2 weeks kind of obtain.
3 weeks, my lord. So positively I will file it, my lord, within 3 weeks.
Okay, 3 weeks. He undertakes that by the next day, the affidavit will be on board.
My lord, I will file it positively.
Much blessed.
I will add another rider will give cost if not filed within a certain day.
From the council, my lord.
24.
Cost will be borne by the council. Yes.
Please, Your Lordship, respondent number 5 would need some more time, Your Lordship, to file the affidavit, Your Lordship. This will be my first time asking them. Last date was I entered
What
appearance.
about
Your Lordship.
3 and 4?
3 and 4,
They
these are
haven't
gone
yet.
ex-parte, Your Lordship.
Yes, they haven't appeared yet, Your Lordship.
These are, I'd like to submit, Your Lordship, these are necessary party,
Your
extremely
Lordship, if
necessary,
I may,
Your
Your
Lordship.
Lordship.
Because these are the authority who had directed us to freeze the account. This is the Karnataka Cybercrime Police.
Your Lordship, if I may submit one order passed by this Honorable Honorable Court, Your Lordship.
They'll never appear. Mr. Day appeared for number what? Number 2.
For 1 and 2, lordship, but we have nothing to add to this matter.
Your Lordship, the petitioner, Your Lordship, freezing of the bank account, Your Lordship, has affected him, Your Lordship, not only him but his entire family, Your Lordship. And Your Lordship, the bank account was freezed since the month of January, Your Lordship.
What is the amount frozen? What is the amount in
Lordship,
dispute? Sorry.
they haven't stated that,
Amount
Lordship.
dispute,
They
not
have
stated also.
no, Lordship.
Lordship, the amount is
Your Lordship, if we
45
come to
lakhs.
In dispute?
This lien amount, me total amount as per the note. I'll just want Lordship.
Lordship, that was never given. That was never served to us,
Lakhs,
Lordship.
which
These are corresponding between the bank and the cybercrime. I just got it. So these are the account, Lordship. There's 6 account. Number 6 is the account of the petitioner, Lordship. This is the correspondent from the cybercrime police station of Karnataka. Lordship. This was addressed to Nulla officer of HDFC Bank.
Lien amount is 45 lakhs.
Yes, Lordship. This is the total amount of the entire account.
How much money do you have in your account?
Lordship, I'm not aware of that.
This is account number 59209366432004. It ends with 3204.
Lordship. Yes,
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 sir.
Lordship. 04, Your Lordship.
You don't know how much money is in your account. Have you stated here?
They have not stated, the amount has not been stated.
Lordship, if we come to annexure 4, Lordship, is this statement?
Lecture?
Annexure 4, Lordship. Page 15.
Just 1 second. This one. (3204), yes.
And also this letter, Lordship, there's a contact number of the police station also. Lordship.
If this account, how come say summary only 17,06,000 on page 21?
No, that's the opening balance. Lordship. Closing balance is 41,380.
Yes. So how's the lien amount 45 lakhs?
No, this is the total amount for this account, for the entire 6 accounts, which is mentioned together in this letter. Lordship.
Or 6 accounts? Yeah,
6 accounts. No, one of them is the account.
Just one
Serial number
account.
6 is
Lien
the
amount
account.
for the account of the petitioner, how much?
This would be, Lordship, that it's not given, but it's totally is 45 lakhs.
No, fine. You should know what's the lien amount for the account. This belongs to other people.
Belong to other people, including the
Then?
petitioner also. Petitioner is at number 6. Lordship.
Right. You can't be so vague, Mr. Marpan. Your banks operating people's accounts, I don't even know.
Yeah.
Yes, take
That,
down. Today, MSEDCM has made a prayer for the freezing account and by retaining whatever lien amount for necessary action to be taken by the bank itself. Stop. Next para, Mr. S. Marpan, Learned Counsel for the bank, respondent number
5. Lordship.
5, has produced a letter dated 7/1/2026 from the Cyber Crime Police Station. It's on MG Road, Karnataka, which shows that the petitioner's account is among 6 accounts for which the lien amount is total to 45,16,900. Ms. S. Marpan, on being queried by the court, submits that he does not have instructions as to the exact amount, which is in dispute. Exact amount as far as concerns the account of the writ petitioner. Stop. It's ready to obtain instructions. Just this matter on Friday.
Hearing? How do you apply?
Lordship, this Friday, next Friday.
This Friday.
Lordship, not possible. This has to come all the way from Karnataka.
Doesn't matter. You take
It will be too early, Lordship. At least
steps.
2 weeks, Lordship. Next week, Lordship.
Okay, next week.
Next week.
Lordship, Monday, Lordship.
Monday, not Monday.
It's holiday.
Holiday. On this.
On the 1st of April.
1st April. Thank you.
25.
Lordship.
Individual affidavit they file.
May I please, Your Lordship. We was into that screening committee.
What affidavit have you filed?
My lord, I have filed on 20th March 2026. Bring in record, my lord, two documents. One is the OE Ordinance 4, my lord, of NEHU, and the notification dated 6/12/2022.
Which one?
This additional affidavit 2, my lord.
Yes.
20th March 2026. I filed. My lord got it, man?
Yes.
By which, my lord, I have brought on record two documents. One is the OE 4, that is the notification of vacancies and preliminary selection under section 24D of NEHU Act 1973. That is annexure 1, page 7, my lord.
Yes.
So I was into the point, my lord, that the screening committee itself, the composition of the screening committee was wrong itself. It was not as per this provision of law. And the basic selection.
But there's no pleadings in your minute.
No, I have pleaded now, my lord. I have brought in record.
Bring on record and pleading.
Yes.
Original petition is not there.
But what in the rejoinder also it is there, my lord. It is there. But what I humbly submit is this, my lord. Now, if it is not a disputed document, my lord, if it is not a disputed documents that these were not the members or this is a fake documents or whatever, my lord, then it becomes a substantial question of law that if it was required to be done in ABCD manner, my lord, and they have done XYZ manner, then the law has not been followed, my lord. This is my humble understanding, my lord. I may be totally wrong.
Okay.
And if it is a substantial question of law, my lord, pleading per se is not required, my lord. So my first, before I go into the other points, my lord, this affidavit, my lord, we have stated, my lord, in para 4. If my lord may kindly see para 3, page 3.
Yes.
That accordingly, the instant additional affidavit is being filed for bringing into record the following documents. So these are the two documents, my lord, that we have enclosed. Now, para 4, my lord, that the petitioner begged to state that from the above mentioned documents, it is apparent that the procedure for the constitution of the screening committee itself was highly illegal and arbitrary. The Vice Chancellor, on whose behalf the Joint Registrar constituted the screening committee, had no authority to do so. The head of the department was not the chairman of the said committee. Further, no professor were included from any other department of NEHU. With a malignant intention, Professor A.S. Dixit appears to have been included 2 times in the same notification for the screening committee. As a consequence, the entire screening process itself stood vitiated. It is humbly submitted that due to the action of the illegal constitution of the screening committee, the application of the respondent number 6 and 7 were screened and allowed, despite they not having fulfilled the basic criteria eligibility for the advertised post of professor, as per the NEHU Ordinance and Regulation, UGC Regulation 2018 and the advertisement. Now, my lord, may I kindly consider para 5, my lord, of my affidavit. That the petitioner begged to state that it is well settled that candidate, irrespective of the category reservation, if any, must fulfill the minimum eligible criteria. In the instant case, the petitioner is aggrieved by the entire selection process as a whole, stating from the illegal constitution of the screening committee and also the subsequent illegal screening of the application of submitted by respondent number 6 and 7 herein, as also allowing separate selection interview process from OBC and general candidates, wherein respondent number 6 appeared twice for the same post and their eventually illegal appointment. That the petitioner begged to submit that the grievances of the petitioner go to the root of the selection process in its entirety. The OBC candidate respondent number 6 herein was screened by the same illegal constituted screen committee. He also allowed to apply for both general and OBC category, which itself is impermissible, and he has also allowed to sit for the same interview twice, and as such the petitioner has ample locus to challenge the entire selection process, stating from the screening of the eventual appointments of the general and OBC candidate. So this is my case, my lord.
Yes, Mr. Sen, he had objection to this affidavit.
My lord, Lordship will kindly see the last order passed by this honorable court.
So we said here maintainability.
Maintainability.
Now,
No, my
now
lord,
he's
my lord, one
also
thing
he's
here.
seeking to
No.
to substantiate his locus.
No, Lordship, one thing here, my lord. Initially, we raised in our pleading about the maintainability. No, this is a service matter, my lord. We have placed the law. My lord, unless a person has locus, he cannot challenge. Now, my learned friend on this submission was very brief, except that quo warranto. Quo warranto, something new he has brought in. He said quo warranto is available. Perhaps though quo warranto is not paid, what he said, Lordship can mold the relief and issue quo warranto. Now, my lord, I am yet to make submission on this. So once he crosses that hurdle, my lord, normally quo warranto, I have brought the law, your lordship. Quo warranto, my lord, will lie only if the person is holding a public office. And what is public office? All this has been laid down by the Supreme Court. In context, recently, my lord, in Karnataka High Court, which has been relied even by the Supreme Court, my lord, that came exactly in context of some teachers of university. A quo warranto was sought. There they said it's only against if the holder is a public office. Otherwise, quo warranto will not. That writ petition was dismissed with cost. So, my lord, he'll have to overcome this hurdle. Now, my lord was generous enough, my lord. Even before he came across crossed the hurdle, your lordship, he has made his submission on various points. So, my lord, I will not shy away from making my reply to those also, your lordship. But in any case, my lord, we will have to satisfy the court that lordship can go into the merit. And even on merit, my lord, I have the answers. So my humble submission, your lordship, since your lordship on the last occasion has said, look into the maintainability.
Yes, we'll hear maintainability. Yes.
So, my lord, as my lord, I said, the pleading, they raised 2 points, what I understood.
You put in your affidavit with regard to the...
and no, they are not reverting it, and they are not even filing a rejoinder to this. Once they don't file a rejoinder, my lord, they are admitting. Second thing, my lord, before I answer to the maintainability, my lord, 2 judgments I will place before this honorable court, my lord, where even if there is no pleading, my lord, even if there is no pleading, it is at an instant of the court, my lord, that something irregularity came, which was, you know, my lord, they have traced it, my lord, and the court interfered, my lord, in that. I will place the judgment, my lord. If my lord may kindly see the compilation of the judgment that I have placed, I am relying only on 2 judgments, my lord. The first judgment, my lord, that is on page 1.
One second. Thin compilation of big...
No, big compilation, my lord. Only 2 judgment, my lord, I am going to rely. Page 7 of the compilation, para 14, my lord. Which we are relying. My lord, if I am permitted to read, we find that the process of conducting separate interview for the post of assistant professor and general and OBC category is wholly illegal. Though none of the parties has raised any dispute about it, but since the same is inherently defective, we are constrained to observe so. Every person is a general category, the benefit of the reservation, this is irrelevant, my lord. So they have seen, my lord, is an unreported case, my lord, of the Honorable Supreme Court, where they have categorically said it was not even the case of anyone, my lord, at that point of time. But here also, my lord, we are saying that the person cannot be called twice, my lord. It cannot be allowed to sit for 2 times interview, my lord.
This happened here, correct?
It happens here, my lord.
I mean, he sat for
general also and for the OBC also.
But the interview was different.
No, it was the same interview. Now, my lord, if we can just visualize.
He appeared twice.
Yes, my lord. And my learned senior has also said yes. My lord, may kindly see the rejoinder.
The only issue was that he applied both under unreserved and under scheduled caste.
Yes, that is correct.
OBC, correct?
Yes, he has applied. But the fact is this, my lord, may kindly see the affidavit which has been filed by the respondent 1, 2, 3 and 4.
Just read out which paragraph.
Page number, my lord. This is the rejoinder filed by us, my lord. page 12 of the rejoinder, this is the select list. Annexure 1. Annexure 1.
Filed on?
This is filed on, my lord. 2/4/2024. This is as per the RTI, my lord. We got this information. He has been screened twice, my lord. My lord, may I kindly see the serial number 7 is respondent number 6.
In the annexure?
Yes, annexure, page 12, my lord.
The page was NCCS, what is this?
My lord?
Scientist profile.
Yes, my lord. Which page, my lord? The rejoinder that I have filed, my lord. Annexure 1 of the rejoinder.
2/4/24. How many rejoinders did you file?
2/4/2024, my lord.
Oh, yes, okay. Sorry.
Yes.
I was into 139. Okay. Too many rejoinders. Annexure 1.
Annexure 1 to, if my lord may kindly see page 12, my lord.
Page 11 is a replied RTI request.
RTI reply, they have given this list of applicants for zoology. My lord, may kindly see serial number 7
Yes, that is.
in the unreserved, and OBC also, my lord, he is there. And for interview also, my lord, he has been called twice, and he has appeared twice, my lord. Now the stand of the respondent number 6, my lord, in his affidavit, he said that the second form may be disregarded. How can it be, my lord, now after he has taken the chance?
Yes. So you're talking about a patent illegality.
Yes, my lord.
Yes.
And if that has happened, my lord, then we have the locus to challenge, my lord. Now, my lord, may kindly see one more judgment I will rely of the Bombay High Court, where they have taken the reference of the Honorable Supreme Court judgments, my lord. I have given the book list, my lord, if my lord may kindly see. Ashish and other versus State of Maharashtra, my lord. 2005 SSC online. 2025.
Is that in a compilation?
No, it's not there, my lord. This is recent judgment, my lord. If my lord may kindly see.
This is Ashish and others?
Yes. Ashish and others versus State of Maharashtra. My lord may kindly see para 15, my lord.
That's another point.
Yes, my lord.
It's not the same point you had just now.
No, this is on another point, my lord, where the composition of the screening committee.
This is selection committee.
This selection committee and screening committee was same, my lord. Selection committee, screening committee also, as it should have been as per the law. Here also it is the case, my lord. It has not. It has been delegated to his subordinate.
What's the finding here?
If my lord may kindly see para 15. Constitution of the interview committee was fundamentally defective due to the delegation of power, which was impermissible, and thus entire process is vitiated. Now, my lord, may kindly come to the para 24, my lord. Para 25, my lord. Just para 25, my lord. If my lord may kindly see, in case of the second para, not just above of 25, para 25. In case of so and so reported in 2011 volume 7 SSC 308, Honorable Apex Court has stated that in case the statutory rule prescribe a particular mode of selection, it has to be given strict adherence accordingly. Also cannot be disputed according to the petitioner, since there was no rule procedure adopted in also proper. Need no further elaboration, since we have observed that manner in which entire selection process is done clearly shows that the integrity of the selection process has been compromised. Here, my lord, what I would like to point out, if my lord may kindly produce the affidavit that I have filed, my lord.
Now, come back to maintainability. There might be, n number.
No, what I am saying,
but whether
what I am saying,
is the correct person to put a challenge to this, whether he has a right to what do you call it, put in his foot in the door.
Yes,
that we're looking at that.
Yes.
Now, whether he's a person now, if we set aside the entire selection,
yes,
whether he'll benefit in any manner?
No, whether he's benefited or not, my lord, that
No,
is
that is the question also.
Yes.
So whether it will not be,
Definitely, my lord.
exercise.
Definitely, my lord.
The selection process might be irregular,
my lord,
not illegal, but there was a selection process.
My lord.
Number one. Number two, now whether the deprivation of the order of the court of the appointment of the respondents will result in a positive effect on the petitioner.
Yes, definitely, my lord. First and foremost, he will not be my senior.
No, we talk about selection process, not a question of being senior.
No,
That
my
you're
lord, my
looking-
lord.
That you're looking ahead. What I'm saying is that suppose you have to be, in the same, like in playing the same game, in the same field. That's the only thing. Not that you're a spectator and you say that, that foul is wrong and you, it's just like that. You're not in the game also.
See, I cannot blow hot and cold at the same time, my lord. One hand, I'm saying that the screening committee was wrong. On the other hand, I cannot say.
No, see, it's just a question of maintainability. So you have to address that. Now, how is he affected? How is he affected? That is how is he affected? What injury has been caused to him personally in his standing?
I will answer to this.
His, within his what do you call it? Situation.
I will
That's the
take
most important thing.
Correct, my lord. If my lord may kindly see in the unreserved list of the merit list, I was
appointed against OBC.
Yes, I'm coming to that, my lord.
So if he was appointed against unreserved list,
my lord, what is my point is, my lord? First round, there's pre-screening and post-screening, my lord. I'm submitting post-screening, my lord. Now he has applied for both the post, OBC and general, my lord.
That's highly irregular.
That is highly irregular.
Yeah.
Now, if that is the case, my lord, the entire selection process is post and pre, my lord. Because of the screening committee, wrongly, my lord, forwarded his application, both in the OBC category also and in the general category also. It is itself is wrong, my lord. The foundation.
But he's unreserved candidate, correct?
I'm an unreserved candidate.
So he comes in a different league. So if suppose he was appointed unreserved post and the screening process was vitiated, like you say,
my lord,
then he's deprived. But the thing is that now he's a different room altogether. He is now he's being appointed again. Like you can see, he has split into categories. He's in the OBC category.
Yes.
He's taking a post OBC. So it's not a question of any other OBC candidate coming forward and saying that by virtue of this irregularity, I am a qualified OBC candidate. He's applied for 2 and so the selection is vitiated. He's an unreserved candidate. His selection, that manner of selection has not been affected. That among those unreserved candidates, there was a separate interview. That is wrong, but then that's been done.
Now, if my lord has seen the apparent illegality, my lord.
Apparently, yes, irregularity. But then how is what injury has been caused to him?
He would have been, if these two people would have not been there, my lord, he would have been above of them, my lord, in the merit list.
How he didn't even figure in the unreserved list.
No, his name is there. The petitioner name is there, my lord.
Right, but then he was not appointed against the unreserved post.
No, he was not appointed, my lord. But the fact is this, my lord. The screening was done by a committee. Screening was done by a committee. And it was not considered, my lord, that it was OBC or general. It was subsequently to be considered, my lord, after the merit list has been prepared.
First you're coming to the selection, then you come to his qualifications, right?
Yes, my lord.
That he's not from the school of...
Yes, my lord. That I have already covered, my lord.
That's the other.
Yes, that is on the merit of the case. Here, my lord, only on the technicalities, my lord, I am, that if the screening committee, composition of the screening committee was wrong, my lord, and that screening committee has forwarded ABCD's form, irrespective of they have applied for OBC or general, or whether I'll be benefited of that process or not, my lord. Now, if I am submitting before this honorable court that the screening committee, composition of the screening committee itself was wrong, my lord. They forwarding
say that it goes to the root of the matter.
Root of the matter, my lord. Root of the matter. Because the moment
what happens thereafter
is irrelevant. Is irrelevant. Now, if in case this honorable court set aside these appointments, my lord, then I will get another opportunity.
How?
I will get an opportunity because the same will be advertised.
Who's appointed unreserved? Someone from unreserved has been appointed.
Yes.
Then
even his also will go, my lord.
You're a party here.
Yes. Yes. Unreserved.
Time for the reserve.
No, Philemon is the...
You're the unreserved. So he'll be affected.
My lord?
You don't have any grievance against him.
No, I have grievance because it's, my lord,
you have grievance against him. Has he been selected wrongly? Does he not possess the qualifications?
Exactly, my lord.
Why not possess?
No. Yes.
Corner number
7. He doesn't possess. According to my allegation, he doesn't possess. But what I'm submitting, my lord, I'm not clear itself, my lord, that I'm in a position.
Very clear.
No. What I'm saying.
Only thing is that you have to,
No, I need to answer my lord queries.
To cross this obstacle.
Yes.
That to show that what legal injury has been caused to the petitioner.
Yes, my lord.
To sustain the petition.
Correct, my lord. That's all. Now, what I'm submitting, if I again can humbly submit the same thing, repeat the same thing, my lord. In a selection process, my lord, an advertisement was published for the employments, my lord. Some people has applied. And these applications, irrespective of OBC or general, my lord, they were supposed to be screened by a committee which is legally constituted. Here I am saying that the screening committee itself was wrong. So irrespective, they forward it for the OBC or for the general, my lord. If I can prove, or if my lord find out that the screening committee composition was wrong and it was not as per the statute, then my lord, I need not go and argue whether he was appointed for OBC or he was appointed for
the whole selection process.
The entire selection process.
Okay. Yeah.
And in the last round also, my lord, where cost was imposed upon me, my lord. On the last round also, we have categorically stated that the screening was wrong. The people who doesn't possess the qualification, they have applied. And on the basis of the Nehu's statement, my lord, my case was dismissed. And now, my lord, we can show from the record the people who was screened, my lord, they should not have been there because they doesn't
screening committee.
Yes, because it is the screening committee, my lord. End of the day, if I can show, my lord, or if my lord is satisfied that the composition of the screening committee was self wrong, then whatever they have done, my lord, that entire thing goes. Then, my lord, whether they have forwarded the application for the OBC or for the general, my lord, even my application, I cannot blow hot and cold that no, because screening committee was wrong and I am claiming the appointment. I'm not claiming the appointment. The entire selection process goes, my lord, whatever they have done. Now, my lord, may kindly see the affidavit that I have filed, my lord. In which manner they should have screened the application, my lord. That is on page 8, my lord.
Today's affidavit.
Today's affidavit, my lord. 20th affidavit, my lord.
Yes.
Now, my lord, may kindly see page 8. Procedure of scrutiny.
Yes.
First, my lord, when the application was called, X number of people applied. And then, my lord, how this screening committee, what should have been the composition of the screening committee and what they should have done, my lord. First, I'll take, my lord, to administrative scrutiny. In the first instance, the non-academic particulars of the candidate like age, nationality, dates of submission of the application, etc. shall be scrutinized by the university office together with the chairman of the screening committee defined below. And those candidates who suffer from any disability shall be listed separately. So it is not, the statute doesn't say, my lord, that OBC and general category should have been separately shortlisted, my lord. It is only the people who are disabled, my lord. Now, my lord, may skip clause 2. My lord, may kindly see the screening of application. So it should have been done by the chairman of the screening committee. Now, who is the screening committee chairman, my lord? They have defined that the application of all the candidates for the post of assistant professor, we are not concerned, associate professor, we are not concerned, professor or equivalent post shall be forwarded by the university office to the head of the department concerned, who shall ordinarily be the chairman of the screening committee. But my lord, may kindly see page 11, annexure 2. Who is the chairman?
Shall ordinarily be.
Shall ordinarily be the chairman.
Head of government should be.
Yes. Shall ordinarily be the chairman. Why they have added this ordinary is a caveat, my lord? Because they have not only defined the screening committee only for the professor, they have also defined this same clause.
But he is the dean, he is the School of Life Sciences.
No, but he is not he is not permitted as per my understanding, my lord. I will take, my lord, to the entire thing, my lord. Shall ordinarily be the chairman of the screening committee. So I will pause here and I will like to take, my lord, to page 11, my lord. That is the notification of the screening committee, my lord. The chairman is the Professor.
So one
and
thing,
Shahardin.
was this notification only for this selection or for across the board?
Only for zoology.
This
Only
is
for zoology. Yes.
Where's written?
My lord, may kindly see the vice chancellor is academic this professor for the department of zoology,
Okay.
my lord. Now, yes. Now, if I can go beyond this, my lord, and submit, the record will speak. As my learned senior was harping on the record, that record is all with him, my lord. Now, the same person, respondent number 6, has applied for professorship for the post of in the department of botany, my lord. And the botany department screening committee chairman was the HOD of the botany, and he has rejected, my lord. He has rejected.
Okay.
In Delhi University, Delhi or JNU? JNU, my lord. He has applied, rejected, my lord. Now it will be for my learned senior to show, my lord, how zoology has accepted if he is not fit for the botany, my lord.
Yes.
Now, my lord, may kindly see serial number 2 of page 11.
Yes.
Serial number 2, Professor Bishanandu Da Roy. He is the HOD, my lord. He should have been constituting the committee, my lord, as the chairman. He is not the chairman. He was made a member. Now, if I can further take, my lord, to this page 8, my lord. Now, there is a caveat. However, if the head of the department happens to be an associate professor, my HOD is a professor, my lord. If my lord may kindly come to page 8, my lord, again. 8, page 8 of the affidavit. That notification, my lord. Yes, screening committee application. However, if the head of the department happens to be an associate professor, the application for the post of professor or equivalent shall be forwarded to the senior-most professor.
So it's overqualified, this dean of School of Life Sciences.
No. But the statute doesn't permit.
Person chairing the.
My lord, here is the case.
This OEs.
Yes.
They are in the nature of statutes.
Statutes, my lord.
Yeah. Okay.
Now, what this caveat was, in case, my lord, my understanding is this: if the HOD is not a
Understood. Yes.
professor. Now, my lord, may kindly see, shall be forwarded to the senior-most professor in the department, failing which, if in case they don't have a senior-most professor also, failing which, the dean of the school or the vice chancellor, it should have been gone to the dean of the school or the vice chancellor. Here is the case, my lord, where the HOD is the professor. And my lord, may kindly see that HOD, the head of the department, shall constitute a committee of not less than 3 teachers in the department. That was done, my lord. Not below the rank of associate professor, including the professor in the department or from the department in the case where there are not enough faculty. That we are not concerned, my lord. Now, my lord, may kindly come to the last line, my lord. Similarly, a committee shall be constituted by the HOD. HOD for the post of professor. So, the committee should have been constituted by the HOD, my lord. This is my understanding. Now, my lord, may kindly see. And then they have also said, this committee shall comprise of not less than 3 teachers and shall include all professors in the department and at least 1 professor from another department in the school or other school. They have not done it, my lord. That is why I am saying that the composition of the screening committee was wrong, my lord. And if that is the case, if my lord, after analyzing the record, my lord, which will be placed before this honorable court, my lord, find out I succeed in this, my lord, then I don't need the locus, my lord. Because I am hitting the root of the selection process, my lord.
Now, one thing, Mr.
Day, my lord.
Day,
yes,
is the line between irregularity and whether it's irregular or illegal. Now, the thing is that, as per your submissions, that now are you mean to say the dean of School of Life Sciences is an incompetent person?
Yes, my lord. As per this definition,
chair the steering committee.
Yes, my lord.
Incompetent.
Incompetent, my lord.
Okay. Yes. We'll continue.
Now I have I have placed a judgment also, my lord. The entire process, if the composition, if like this Bombay High Court judgment, my lord, where they have relied on the Supreme Court's judgment, the composition in that case, my lord, what has happened, my lord? A particular group of people should have been the members of the selection committee. What they have done, my lord, instead of them, they have delegates the power to conduct the interview by their subordinates. The Supreme Court said no. It has to be followed the statute. As per the statute, only they can do it, my lord. And the entire process was declared as illegal, my lord. So two things, my lord, from this affidavit I would like to stretch. One point is this, my lord, that when the composition of the selection screening committee was wrong, my lord, then the Bombay High Court judgment benefits me, my lord. It's cover my case, my lord. And one more point is this, my lord. It also hit the root of the selection process. Yeah. If my lord may kindly see. In the same interview, my lord, for example, my lord, if I can just 1 second. Yes. If I can say, my lord, by seeing this affidavit, rejoinder of mine, that, my lord, he was screened 2 times, the same person, and he was also called for 2 interviews, my lord, and he has appeared twice. Now, for example, my lord, if like, my lord, if I go for an interview before my lord, and a particular question was asked, the similar question may not be asked, my lord, but at least I will be able to understand what is the mind setup of the interview board, my lord. Then advantage will be definitely there.
Screen twice.
Yes, my lord. Screen twice
and call twice for interview.
Call twice for the
and
interview.
Appear twice for interview.
And appear twice for interview. What they should have done, if we see, my lord, the judgment of the first judgment, it covers my case, my lord. But if my lord go beyond that judgment and see another judgment of the Supreme Court, my lord, in that judgment only they have relied, my lord. If, my lord, we are not saying, my lord, that a person cannot participate in the selection process and he cannot be considered, if he apply only for general, he cannot be considered for OBC, or if he apply for OBC, he cannot be considered for general, my lord. The proper procedure should have been, my lord, after screening, my lord, they should have given forward the application. The selection committee, my lord, should have given the marks according to their wishes, my lord, and from there, my lord, they should have at least, my lord, segregate for the reserve who was proper, my lord, and for the unreserved who was proper, my lord. My lord, may kindly see again the judgment compilation, page 7, my lord. Compilation paragraph 4, my lord, 14, my lord.
Yes, that you've seen.
Yes, I have read half of the paragraph. I would like to again go through that paragraph again, my lord.
What you've reprised a live law judgment, is it correct?
Is correct.
Where's the reported case?
We'll give
can you kindly
yes, definitely, my lord, definitely, my lord. I will
rely on this live law or not. Sometimes
yes. Yes,
you kindly
online
Bombay.
This
This is the Supreme Court.
Yes.
You kindly find you bring the reported. Yes,
we will get it, my lord. But this is a judgment.
Of course. Yes.
If my lord, just see the second paragraph. The benefit of reservation is conferred to the scheduled caste. If my lord got it, my lord.
Yes.
The benefits of reservation is conferred to scheduled caste, scheduled tribe, and OBC candidates, category candidate, or such other candidate as is permissible under law. It is as constrained view of this code stating so and so that if a reserved candidate category candidate is in merit, he will occupy a general seat. Our case is not this, my lord, that he cannot occupy the general seat also, if his marks was higher than the general candidate. Yes, my lord. Yes, we'll give it. The next point, my lord, if my lord may kindly see, I have argued, my lord, in length about the qualification of respondent number 6, that even he doesn't satisfy the qualification which was as per the advertisement, my lord. I need not take, my lord, again to those outstanding professional and all, my lord, that I have argued in length, my lord.
Yes.
Now, if my lord may kindly see the affidavit of respondent number 7, my lord.
Number 7 is
Mr. My friend.
He is the person appeared twice.
No, Mr.
General category.
He is general category. So what we are saying, my lord, from
Number 7.
Yes, my lord. If my lord may kindly peruse the affidavit that has been filed by respondent number 7, Dr. Timir Tripathi, my lord. Page 10, my lord. Academic qualification.
Yes.
Academic qualification 2.1, my lord. It is in the second.
We read the
page 10, my lord. Page 10 of the affidavit. It is the biodata that he has enclosed, my lord.
Yes.
He is from unreserved candidate, my lord. If my lord may kindly see, bachelor, BSc degree, chemistry, botany, zoology, master degree, biotechnology, my lord. And he doesn't have the specialization as mentioned in the advertisement.
So you want a maintainability question?
No, is this two, my lord, because I have not argued yet for respondent number 7. It was only in respondent number 6. My learned senior was pointing out that it is not maintainable because of respondent number 6, my lord.
Yes.
Regarding this life law, my lord, if my lord may kindly.
Number 7 is not maintainable.
Yeah, both
Number 7 is not maintainable. He's taken part in the entire process after being on.
I will place the judgment, my friend. Let him come down, my lord. I will place it, my lord, the judgments and all. Whether I can take, I can challenge their appointment when I have taken the. My lord, may kindly note down, my lord. 2019 SSC online SC 1216, my lord, that life law judgment. 2019 SSC online SC 1216, my lord.
Okay. Pradeep Singh Dayal. So what have to show from this page 10?
Page 10, I want to show, my lord, that what is the qualification of the respondent number 7, my lord.
It's got zoology.
No, my lord. It is in the BSc, my lord. In master degree, my lord.
Biotechnology doesn't belong same school as zoology.
No, my lord.
Life sciences.
Life sciences.
My lord, may kindly see in life science what was the specialization which was required, my lord. Specialization. My lord, may kindly see the term of the advertisement. If my lord may kindly see the writ petition, page 35, my lord.
Where is the petition now?
Writ petition of mine, my lord. Oh. Yes. Read that. Page 35, my lord.
Yes.
My lord, may kindly see zoology serial number 38, my lord. Zoology, professor, number of post 3, categories, we are not concerned, my lord. Now, specialization, my lord. Aquatic biology, fishery, animal physiology, molecular biology, biosystematic, animal ecology, and entomology, my lord. He doesn't have, my lord, he himself, he has mentioned, my lord, it is biotechnology in his MSc, my lord. He doesn't have this specialization. Otherwise, he would have, and if he has, my lord, let him produce.
Specialization.
Now, my lord, can you see?
Has already been gone into the first writ petition, I think, doesn't matter.
My lord?
What happened? Appeal was filed. What happened?
No, appeal was not filed. That was improperly my client. Appeal was not filed.
Appeal against this order, there was a regarding eligibility that was disposed of. Correct?
Yes.
The order there.
Yes, it is on page 63, my lord.
Of the petition?
Of the petition, my lord. If my lord kindly produce para 8 of that order, page 63. A perusal of the criteria as given below shows that an applicant is eligible to apply for the post of professor if one of his eminent scholar having a PhD degree in a cognate allied relevant discipline, the School of Life Science having included other departments such as biochemistry.
Then this issue is not open for discussion any longer.
It's only a specialization, my lord.
No, but it's not. It's already decided there in the earlier round.
No, my lord. What I'm saying is this. What I'm saying is this. An incorrect statement was made, my lord. An incorrect statement.
Appeal against this order.
No, I have not appealed against the order, but I'm in the second round of litigation.
You can't adjudicate with regard to the eligibility of this one number 7.
Only on specialization, my lord may kindly see.
We'll not hear that. Yes, continue on other parts. Yes.
If my lord is saying that
see, at that point of time the matter was heard regarding eligibility, right? Now, screening committee was not. It did not say that you did not challenge the constituent screening committee in the first round. As I just now, you challenge only that the screening committee has forwarded eligible candidates.
Correct.
And now this court had heard you at length and heard the respondent and found that under School of Life Sciences, biotechnology is part and parcel of that. And so, if it is included there, that means have a PhD in a certain in biotechnology or MSc, whatever.
We have no.
He is eligible.
We have no.
That is done.
No, my lord. What I am submitting is this.
Yes.
On the first round, I was not there, but I don't know what was the.
If you been there, maybe the outcome would have been different. But you can't.
Maybe, my lord, if my senior would have allowed me.
Now you can't repair what's.
No. What I'm saying is this, my lord.
That part, that aspect, you have to abandon because you can't repair that.
No, my lord. What I'm submitting is this, my lord.
Yes.
If a wrong statement was made and that was considered, my lord, can res judicata lie against of me?
Then did you appeal? Appeal against order now. File an appeal.
No, that my lord, my client need to take a call on this, my lord.
Take a call on this. Then you can't come and rake up things like that.
And second point, my lord, we are not in this point, my lord.
This point abandoned.
Well, we are only on specialization, my lord. Whether he has the specialization
we're not
or
going to go there. Eligibility of one number 7 has been already decided by this court in the earlier round litigation. Because that's closed chapter. That room you can't go inside anymore. Now you go into the room of maintainability.
My lord, my kindly see, this is not what the order speaks. What the order says is about the main subject, my lord. But whether specialization he has or not,
you can't split hairs. You file appeal. It's up to you.
My lord is
it's a vexed question, yes. But then if you seeking the relief that he's seeking, but on a qualification, eligibility, I don't think it's open for discussion. Of number 7. Other facts, yes, okay, fine. We can examine whether the process is illegal or irregular.
So
irregularity, whether it can be condoned.
Then we'll confine.
If it's illegal, no. Irregular, maybe.
That's for my lord, and we are just supposed to please the facts, my lord. Correct.
No, but we're not going there again because instead of rehashing everything that has already been decided.
That was properly not advised to my client at that point of time. Probably, I don't want to comment on that, my lord.
No, we can't say anything about that. Yes.
So, what my learned friend has said that I cannot challenge the same selection process if my lord.
You've taken part.
I have taken part, my lord. Then I will rely on one judgment, my lord.
Yeah.
My lord, can you see there again, my lord, the spiral binding, page 12, my lord. It is a judgment of the High Court of Tripura, my lord, but they have relied on the Supreme Court judgment, my lord. Rangchak Tripura versus Tripura University and others. Page 10, my lord.
Yes.
If my lord may kindly come to page 5, my lord.
Yes.
Page 12, my lord. Para 5. That Mr. So-and-so, Roy Burman, learned senior counsel, appearing for the writ petitioner, on the other hand, submit that the challenge regarding the recruitment process as put forward by the petitioner is twofold. First, that in the midst of the recruitment process, the rule of the game was changed. And secondly, that the said alteration was made with malified intention just to enable respondent number 4, who is the son of so-and-so, to participate in the selection process, and thus in a complete unfair manner. He was favored with the job, and therefore the entire recruitment process is vitiated by unfairness, favoritism, as well as arbitrariness. According to the learned senior counsel, the writ petition cannot be disposed on the ground that once a person participates in the selection process cannot challenge its procedure. According to Mr. So-and-so, learned senior counsel, even if a person participates in the selection process, he has the right to challenge such process if the said selection process is not conducted in the fair and with transparency, as required under Article 14 and 16 of the Constitution. Learned senior counsel in this regard also relied on a decision of the Honorable Supreme Court in so-and-so, reported in 2019, Volume 20, SSC 17, wherein at para 17, it was observed that a candidate by agreeing to participate in the selection process only accept the prescribed selection procedure and not the irregularities in it. And in the situation where a candidate allege misconstruction of the statutory rules and is discriminating consequences arise therefrom, the same cannot be condoned merely because a candidate has taken part in it. The relevant para number 17 of the said judgment is extracted below. If I am permitted to read, I will just read out. However, we must differentiate from this principle insofar as the candidate, by agreeing to participate in the selection process, only accept in the prescribed process and not the illegalities in it. In a situation where a candidate alleged misconstruction of statutory rules and discrimination consequences arise therefrom, the same cannot be condoned merely because a candidate has taken part in it. The constitutional scheme is sacrosanct, and in violation in any manner is impermissible. In fact, a candidate may not have locus to assail the incurable irregularities or deterioration of the provision of the Constitution unless he has participated in the selection process. So here, my lord, they are saying that even if I participate, I agree with the correct procedure. I'm not agreeing what wrong they have done, my lord, so I am barred for that.
Yes.
Now, my lord, may kindly see, this Nehu did not even notify the select application. They have not notified the people who has been selected. They have not notified. It was not yet.
The select list.
Of the select list.
Recommended candidates or the
what
the
screening, the screen application
committee did not publish the names of people who are
who found eligible. Yes, my lord. They have not done it. Normally, my lord, if they would have done, my lord,
is that a mandatory requirement?
It may not be, my lord, but for transparency, my lord. Even the merit list. Even the merit list was not published, my lord.
Meaning?
Merit list. The people.
The result sheet was not published.
No, my marks was not given to me.
No, not marks. I mean, the list was not published. These are people selected.
No, my lord.
Then what list was that you showed?
This, my lord, on the basis of an RTI, they have given me. And moreover, my lord,
there was no result list published.
No, my lord.
It's not a public domain that this is the persons who have been selected for the professor.
No, my lord. No, my lord. No, my lord. There's hundreds of RTI.
But he has not made this kind of pleadings here.
My lord.
Obviously, it has to be. If there is a merit list, might have been circulated. What is not in the pleadings? Okay. It's very, normally,
with due respect, my lord, with due respect of my senior, my lord, I don't want to comment what he's saying, but my lord, after the intervention of this honorable court, only the result was given to me, who was appointed, my lord. And I came to know that Mr. XYZ was appointed when I checked in the website, my lord. But nothing is there in the website. Nothing was there that respondent number 6, respondent number 7 was appointed. After the intervention of this honorable court only, my lord, that document was furnished to me. I have filed numbers of RTI to obtain all this information. Now, why I was handicapped, my lord? Because no reply was given. They was given a proper legal advice that don't give. By whom I don't know, my lord. I'm not saying my lord, I see here.
Yeah, you are casting, you know.
No, I'm not casting. I'm just saying.
Pointing. Yeah.
No, I'm not. I'm not pointing, my lord.
You're pointing without pointing.
My lord, I'm extremely sorry. It was not my intention, my lord. But the fact is this, my lord. Number of RTI, I can see a compilation of RTI, my lord, where they have not given even my marks, my lord. Where I stand. It is very, very unfortunate.
So where do you stand your marks vis-a-vis respondent number 7?
I don't know, my lord, how much marks. I don't know how much marks I have obtained.
Okay. Yes. Proceed. Yes.
Now, if that is what Nehu is doing, that is totally wrong, my lord. And we are bringing into the notice of this honorable court, my lord. So, two things, my lord, that what Mr. Philemon has argued, my lord, that, or he will be arguing, that I cannot come back because already I have participated in the selection process. So, I place the judgment, my lord, that allows me to do that if they are just irregular, wrong process. Now, my lord, again, coming back to the maintainability again, my lord, why it is maintainable to challenge one, Mr. Philemon, I have no issue with his client, Mr. Respondent number 7, with Mr. Philemon's client, that because I am also general category, my lord, I can challenge. But since my lord has said that the qualification cannot be challenged now, so I will only, my lord, challenge to the extent of screening committee, my lord. And that is permissible, my lord, for me.
Yes.
And then, my lord, the respondent number 6, my lord, even if he is an OBC, my lord, I'm hitting at the root of the selection process, my lord. And selection process start from the time of advertisement, my lord. My lord, before I, my lord, wind up my submission, my lord, I would like to take, my lord, to the Bombay High Court again, my lord, judgment. I have read para 15, my lord. I would like to read only 24, my lord. It's a small paragraph, if my lord permits me.
Yes,
they have relied on a Supreme Court judgment.
Bharat Vijay Kumar Balakrishna.
My lord, para 24, my lord, of the judgment.
Just 2011 7 SEC.
Yes, my lord. 2000. Beginning of para 24, my lord. Page number is not given, my lord. Para 24, my lord, if my lord may kindly see. When entire selection process is tainted, then there cannot be pick and choose policy of certain candidates. Integrity of selection process is full of doubts, and thus entire selection process is required to be set aside, my lord. So if, my lord, the selection committee, constitution of the selection committee itself was wrong, my lord. Now my learned friend cannot say that, my lord, because I am barred by Reg Educator, my lord, I cannot challenge this. So the entire selection, if it is stated in my lord, then the entire selection goes, my lord. I reserve the right to give a small rejoinder to the submission made by the other respondents, my lord.
May it please your lordships. You know, my lords, the grounds of attack, my lord, numerous. It's very difficult, my lord, to retain in the mind. Any case, my lord.
That is a compliment or not, my lord, I don't know what it is.
More than, I think, my lord, 20 grounds he has to take in your lordships. Now, my lord, anyway, my lord, I'll just try to organize my submissions. Now, my lord, initially the point we have raised, my lord, the maintainability. Because our humble submission is that unless you cross that hurdle, you cannot get into the merits. And I have cited the decisions also, my lord. You can give it to the court, no? My lord, in fact, I have prepared a brief, my lord, with the relevant judgments and a brief compilation, your lordships. Now, my lords, before I come into the maintainability, my lord, the facts very shortly, if I can place the facts. Now, he has a lot of problems with the qualifications. What is the code? You are one respondent number C, he is from, my lord, biotechnology, bioinformatics. He did his master from bioinformatics. And respondent number 7, my lord, did his master from biotechnology. So he has a lot of problem. His claim is that I am from geology. I have done my master from geology. So I am the rightful person, and they do not have the. This is one of the plank of the submissions. Now, my lord, this is totally misconceived, your lordships. Now, what is biotechnology, my lord? Quoting the source, my lord, I have referred to in my compilation. Where is that page?
No, but do we have to go there?
Yes,
again?
yes, my lord. I'll just point out one thing. I'm coming because he knows what is biotechnology. I'll just point out that even the writ petitioner fully aware, my lord, it is relevant. I'll just come to that. Before that, if I can take, my lord, briefly. Now, what are the definition of biotechnology and bioinformatics? You've given. My lord, we start with biology, my lord. That is a, my lord, study of life science, my lord, generally. Then comes zoology, my lord. Zoology of study of the life of the animals, both, my lord, in the water.
Can you reading which zoology, a branch of biology concerned with classification of properties and vital phenomena of animals?
Yes.
Okay.
This is the biotechnology, and in the bottom, if your lordship comes to bioinformatics, next, the collection, classification, stories, analysis, biochemical, biological informations using computer, especially applied in molecular genetics and genomics. So, my lord, saying that these are not relevant for study of geology, my lord, is totally misconceived. And we as a layman, your lordships, I'll just come to those decisions, my lord. We cannot travel beyond this. Now, one of the submission is this thing that you should be from a geology background, master in geology. That is the prime contention of the writ petition. Now, how the writ petitioner started? What he said, my lord, biotechnology, bioinformatics, this is stranger. This is something stranger to geology. Now, how he started his career, it is in the writ petition. My lord will come to page. His career voucher he has annexed. Page 28, annexure 1 of the writ petition, page 29.
1 second. Page 28.
Yes, my lord. Start from page 28. There is the career voucher of Vidyadhar Das, the writ petitioner. My lordship will come to the next page, 29, under the heading Employment History. Associate Professor Geology, Northeastern Hill University till 2021. Then Assistant Professor Geology, Northeastern Hill University, April 5, 21. Then in the bottom, Assistant Professor in Division of Technology, that is the Department of Biotechnology, Manipal University. But this is something when you're playing with the court. I no say that he cannot hold.
He started as from
Exactly, my lord. So saying that in the same hand, my lord, he himself was holding. This is playing with the court and wasting the valuable time of the court. He is sitting here. How will answer that?
Yes.
We should not play with the court, my lord. Now, my lord, coming to other thing. Now, other plank of submission. Specialization. There is no certificate for specialization. No institution issue, my lord. If I do a MSc, my lord, in a particular, they will not issue a certificate for my specialization. That is to be gathered how, my lord? For my research and academic activities done by a professor. The journals he has written. The PhD on the subject he has done. Now, these we cannot decode these words. It's very difficult for the court and the lawyers to do it. Who does it, my lord? The expert sitting in the selection committee.
Yes.
I will just 1 second, my lord. One second, please, my lord. My learned senior is misleading this honorable court. This is the MSc degree where specialization was written. How come this kind of
let me finish.
No, let me just point out. Just so
he started his career.
No. It's not that, my lord. Specialization. My learned senior has submitted. My learned senior.
Rattle and this thing. He can always answer. He can hold down.
Just let me just point out, my lord, whether in master degree, my lord, they give his specialization or not. This is my mark sheet, my lord, and my lord can produce.
Okay. Yes.
How can this
now, my lord, coming to now, my lord, this now how, my lord, the specialization mentioned in the advertisement, my lord. This is no way certified, your lordship. This is to be gathered from the academic activities, research works. I'll come to that more elaborately, my lord. And the PhD on the subject we have done. This cannot be decoded by us. It's very difficult, my lord. I tried, you cannot. Now, this belongs to the domain of the expert. Till from 1965, my lord, that constitution and judgment of Mysore University, they have caution time and again. That is a 5 judges bench judgment, your lordship, which is still relied on. Don't get into the expert domain.
Right.
My lord, I have annexed those statements. Now, my lord,
Yes.
Now, my lord, this advertisement was made, my lord, in the year 2022.
Yes.
2022. Based on the selection procedure of the UGC, which was notified in 2018. 2018.
Yes.
Now, my lord, 2018, my lord, by this time, my lord, with the idea of, my lord, digital India, thing has gone online. There is a substantial sheet of process of recruitment, what it was in 2010. Because 2018 replaced the 2010 UGC notification. Now, my lord, everything has gone online mode. That's why, my lord, the advertisement, it was mandatory to be applied online.
By online.
Online. Now, my lord, online, my lord, even the marks, I'll just take your lordship to that UGC regulation 2018. The score for academic and research activities, this is no more manual. These are auto-generated. Once it is submitted, my lord, it is auto-generated by the computer, marks. It is categorically mentioned in the UGC regulations. Now, interesting thing, your lordships. So, for academic activities are concerned, research scores are concerned, lordship will see, my lord, all these papers are here, they have annexed it, it's not pointed out. Lordship will see. For academic activities and research, my lord, so for the marks of respondent number 7, who topped, your lordship, his score was over 2000. Over 2000, my lord, it is here, your lordship. Reserve category candidate, of course, my lord, 500 something. And he stand at distant, my lord, 500 something. Could not even cross 1000. And now he is challenging, my lord, the appointment of private respondent number 7. Lordship comes kindly to page 47
of
the writ petition. Well, page 47. You will see, my lord, under the heading column, research score claim. That is the claim by the 6.3. Research score earned as per the guidelines of the UGC. These are all computer generated, my lord. 637. That is a substantial part of marks by the expert given on the basis of the marks scored here, my lord. This is very relevant, my lord. The substantial portion. Now, my lord, if I can take, my lord, to respondent number 7, my lord, in the affidavit, filed by the respondent number 7. At page 9 of the affidavit filed by respondent number 7.
Yes.
Now, lordship will see
2015.
2015.3 and 2015. And these were, my lord, if your lordship want to see, my lord, that these were placed before the selection committee. Selection committee, my lord, they cross-checked, found to be correct, and marks was allotted on the basis of these high scores. Now, my lord, similarly, of course, my lord, since he belonged to reserve category, he is something 500 something, my lord, reserve category candidate. Now, my lord, before I get into, my lord, I did not want to, my lord, take too long time. I'll go back to the maintainability, now, your lordships. Now, maintainability so far, your lordships, the admitted position is this.
But Mr. Sen, you admit that very irregular the way the selection was done for the
no,
number 6.
I'll
Why?
just,
How can you allow 2 applications and 2 interviews?
No, that I'll explain, your lordship. That decision, my lord, I'll try to distinguish that decision.
That's the only thing.
Yes.
But whether he can, crossed that line to challenge.
I'll answer. I have
the
answered.
fact that what's come the notice of the court is this has happened. That the selection, you see, is one of the 6 now.
2 interviews.
How can he face 2 interviews?
2 interviews.
Suppose you go for a civil service interview. Now
it's different here.
Suppose will it be accepted that
it's different.
So far, my lord, be accepted as unreserved and general, because if you qualify, if you do well, you will take a reserved seat.
All right, my lord.
And if you don't, you come. If there's shell type, shell car seat available, post, he'll be comment against that.
But the things are different here.
Because unreserved means unreserved for everybody. You can it includes everyone. So it depends on when the merit list.
Okay.
And so there can't be 2 interviews that we'll have a separate consideration for consideration only in the question of the qualifying marks, cutoff marks maybe from the same exam.
Okay.
But not excuse me. Yes.
But things are a little different in the university. But I'll try to distinguish that Himachal
Now
Pradesh.
tell the court whether this has been ever done before.
Always.
Always. For OBC.
But there is a provision. There is a instruction from the. My lord, if I come to that decision my learned friend 2019 has referred to, that pertains to a selection with reference to the UGC regulation of 2010, when my lord the mode was not offline.
This
number 1,
screening committee.
Yes, and then number 2, that was pertaining to a state university. That was not a central university. That was not a central university who were following the norms of the UGC, my lord.
Okay.
In their case. Now, my lord, subsequently, after switching over to the offline mode, my lord, there is no provision to file a single application for both general and reserve. It is
show the court where it's possible that you file 2 applications.
I'll show. I'll just come back to that, man.
That is the only thing that strikes the mind of the court. Whether he has the right to challenge or not doesn't matter. But whether that practice can be allowed.
Lordship, I'll just come back.
Yes.
Now, plus there is a my lord provision also. I'll just refer to my lord. Before that, if I can finish that, my lord, maintainability.
Yes, okay, maintainability.
Now, maintainability.
How much longer will it take?
It won't take much time. Because I have already, my lord, in the compilation, all these judgments are there. My compilation. My lord. Now on maintainability, what we are saying, my lord, admitted position is this, my lord. He is never a contender for the post of
OBC.
OBC. Never a contender for the post of. And the leading judgment, my lord, in this thing is that 2002 1 SSC, my lord, page 33, relevant paragraph is 38. There is a Supreme Court judgment, my lord, Ghulam Qadri versus others.
That is page in a compilation.
Page 22.
Ghulam Qadir.
Ghulam Qadir. That is the
yes, para
square page 38, my lord.
Para
38.
Para 38.
Page 22. But if I can just read it. There is no dispute regarding the legal proposition that the rights under Article 226 of the Constitution of India can be enforced.
1 second.
Okay. Your Lordship has got it.
Yes.
No.
Yes.
There is no dispute regarding the legal proposition that the rights under Article 226 of the Constitution of India can be enforced only by an aggrieved person, except in the case when the writ prayed for is of habeas corpus of quo warranto. Another exception in the general rule is the filing of a writ petition in public interest. The existence of a legal right of the petitioner which is alleged to have been violated is the foundation for invoking the jurisdiction of the High Court under the aforesaid article. The court has undergone a sea change with the development of constitutional law in our country, and the constitutional courts have been adopting liberal approach.
Where are you reading from now?
38, madam.
Yeah, the existence of legal right of pressures which have been violated, foundation and organization of the orthodox rule interpretation. You're reading where?
Paragraph 38, madam. Yes. Again, I just read it from the existence of legal right of the petitioner which is alleged to have been violated is the foundation for invoking the jurisdiction of the High Court under the aforesaid article. The orthodox rule of interpretation regarding the locus standi of a person to which the court has undergone a sea change with the development of constitution and law in our country, and the constitutional court have been adopting liberal approach in dealing with the cases or dislodging the claim of a litigant merely on hyper-technical ground. If a person approaching the court can satisfy that the impugn action is likely to adversely affect his right, which is shown to having source in some statutory provision, the petition filed by such person cannot be rejected on the ground that he is not having the locus standi. In other words, if the person found to be not merely a stranger having no right whatsoever to any post or property, he cannot be non-suited on the ground he is not having locus standi. So even after adopting a liberal approach, which is at least some kind of right, my lord, some kind of stake there, he has never applied for that. So, my lord, my humble submission, my lord, this is not maintainable. So far with 6 is concerned, respondent number 6. Now, my lord, the other decision of the Guwahati High Court, my lord, that is, my lord, 2007 SSC online, 436 page, para 7.
(2008)
2007 SSC online. It is there in the compilation at page 48.
1 second. In the compilations, page 39.
No, my lord. I'm sorry, my lord. This is in page 39.
So you said 48. It's page 485.
39. 39 paragraph. Paragraph 3, my lord. Sorry. 3 and 4. This is of the Guwahati High Court, my lord, and is related to Nehu only, my lord, if I am not correct. It's Nehu, no? Yes, it's related to.
You are a counsel there only?
Yeah, I'm the counsel.
Remember this Xavier P. Mao, very famous case.
But he filed a case, my lord, and this is the view of the division bench. According to the petitioner, they had applied to the seat post along with others as they are having specialization as required to the post of reader, but the screening committee headed by the head of the Department of Philosophy of Nehu as its chairman has allowed only 5 candidates to be called for the interview, whereas none of them have requisite specialization. But the petitioner were not called for the interview despite the fact they were in possession of required specialization. The selection committee, comprising of 7 persons, including the Vice Chancellor of Nehu as its chairman, has Vice such and such recommended C.L.N. Lanka, the sole candidate suitable for appointment to the post in order of merit. The petitioner had sent a representation dated such and such to the Vice Chancellor, Chairman, Executive Council, Shillong, challenging the sage, especially requesting them not to appoint any person as reader in the Department of Philosophy, Nehu, as the sage selection was defective and was suffering from many procedural deficiency as well as was contrary to the provision of the statute. According to the petitioner, section OE 5 such and such Nehu ordinance was not to be relaxed and changed. When the specialization in philosophy of religion was required for appointment to the post of reader in philosophy indicated in the advertisement, then the screening committee as well as the selection committee was not empowered to relax the requirement of criteria of regularization and to adopt the law. According to the petitioner, as per 20 such and such of the statute, the expert having specialization in the subject concerned, according to the petitioner, the following aspects are important to be taken into consideration. 1. The expert constituting the committee were expected to be in possession of the specialization in subject concerned, specialization in philosophy of religion, etc., anthropology, however specialized in the subject. Even none of the candidates who participated in the selection were having the records of the petitioner were not considered, and their research and published works too were not looked into by the screening committee. The selection committee has not indicated any criteria or parameter in respect of allotting marks to the candidates. No panel of selected candidates according to the merit was prepared, and only by the private respondents who were recommended for as many applications. My lord, 4. If I can go to 4, my lord, paragraph 4. On the other hand, it has put the counsel for the petitioner, the committee constituted by the head of the Department of Philosophy scrutinized all the application of the proposed candidate.
Yes.
My lord.
He head of the department, he's a committee head.
Committee, my lord. Committee considers the head of the Department of Philosophy and News scrutinized all the applications of the proposed candidates, including the petitioner, and it was found that only the 6 candidates were eligible to be called for interview, out of which only 4 candidates called for held on such and such. The selection committee comprised of 7 persons, including the Vice Chancellor and the Chairman, had on merit found Sri Lanka most. Therefore, and in an usual way, Dr. Lanka alone was rightly recommended for appointment. But I'll just take your lordship to the relevant part.
What's the finding?
Yes, yes, my lord, I'm just coming.
You're looking at the previous case and this
Yes,
is your
2002, my lord, I'm sorry.
Yes.
2002, one review. This is not 2002.
Paragraph 18 with us, sir.
Anyway, my lord, if I can take your lordship to my lord 2000 next judgment 48, page 48. Page 48.
Now this is for defective selection process.
Yes, my lord. And
It goes against you.
yes.
No, it's not against me, my lord.
Let's see para 17.
I have this judgment, my lord.
No, I'll just rely, my lord.
See, many of the aspects are already intended to impress upon, however, they are not relevant for adjudication in the cases. Selection right from advertisement, screening procedure, and giving a point of Lanka of the post reader in so-and-so department, apart from being consonant with the statute, discriminatory, unfair, defective, non-constitutional, the court also create doubt with the following information. That's the process upon Lanka are defective, so-and-so. Now, he was not allowed.
This appointment was set aside, my lord.
No.
This matter. Yes,
This is
I have a copy.
this I'm coming here, lordship. This is judgment.
No, what is the, why you want to place this judgment?
It helped my case, my lord.
Yes.
I'm just coming here, lordship. They are finding out the relevant paragraph. In the meantime, if I can take my lord to the next.
But the finding is that you said that the whole selection process was defective.
2008, 2002, one SSC.
In this matter, my lord, the petitioner never participated in the selection process. Even then, my lord, it was allowed.
Which matter?
In this judgment,
You
what, my
will
lord?
team out.
Yes, my lord. I have a copy.
I think there must have been an appeal against this.
This has been set aside, my lord. I mean, wrong judgment has
This
been.
wrong judgment
This
is-
Lanka I have appeared. This was by justice, this thing. But there was an appeal that has been set aside. This judgment has been set. I'll please
Where's
that.
the appeal?
That appeal I'll find out. Wrong judgment. Anyway, if I can take my lord to page 48.
Putting a dagger to your own throat.
2007, 436.
2007? Okay.
Para 7. When the court made a pointed query as to the availability of any decision of the apex court on the maintainability of PLD in service matter, no such authority submitted by the petitioner. On the contrary, Mr. Sen, the learned counsel appearing for the Nehu cited the case of Shahu versus such and such, in which the Supreme Court has held that PLA is not maintainable in service matter. The aforesaid proposition of law is reiterated by the apex court in Gurpal Singh versus State of Punjab. In this case, a division bench of bench of Punjab and Haryana High Court held that the appointment of the appellant herein as auction recorder of the market committee is invalid and illegal, and the said order of the High Court came to be passed on the basis of the writ petition filed and stayed as public interest litigation. On challenge before the Honorable Supreme Court, the apex court held that the service matter public interest litigation cannot be filed and is not maintainable as such.
The first judgment, the Kadri judgment covers.
Kadri judgment covered everything.
That is the landmark.
Yes.
So,
Now, my lord, the only thing, my lord, while answering this, my learned friend has only referred to quo warranto. Now, quo warranto is an exception carved out, my lord, I admit, in service matter. Now, my lord, in what situation? The situation, my lord, they have clearly spelled out. The person against whom the petition is filed, he should be holding a public office. And what is a public office, my lord? There should be an element of sovereign function. Element of sovereign function. Now, were these humble teachers, my lord, what kind of sovereign function they are discharging? Exactly that issue, my lord, recently came up before Karnataka.
Sovereign function will come when he acts on his own capacity.
Obviously, my lord.
He holds the rules and
For example, my lord, the vice chancellor. Vice chancellor has been held, my lord, holding, my lord, a public office. Quo has been issued. Now, when it comes to, my lord, the teacher, my lord, it has been held. They are not teacher. They are not holding any public office, and I'll just rely on that judgment. Which is that judgment? Huh? Karnataka. This is Kerala. Karnataka. My lord, that is at page 157 on Quarento. This is 2025 SSC online, my lord, 4715. My lord, I'll take your lordship to 5.1 onwards. Of SSC 2025 SSC online, Kerala.
I don't think we can complete this matter today.
No, my lord, with this, my lord, I'll wind up on maintainable with this judgment, because this is the only thing he's saying Quarento lies.
Please, sir.
Page 471. 471.
Yes.
Man.
This is 4.1 onward, you say.
5.1 onwards. If I can take my lord.
Yes.
Since the petitioner have prayed for the writ of Quarento, the essential for issuance of the writs needs to be adverted to the outset. The writ of Quarento is a special kind of prerogative writs. The Constitutional Code may issue the writ of Quarento to unseat and oust the holder of public office or public post. When such holder is found to have occupied or usurped such post, even though the holder does not fulfill the statutory eligibility criteria for the post, and that he is unqualified to hold the post. 3 ingredients are necessary to be satisfied before the writ of Quarento could be claimed. First is the post of the office held by the person against whom the writ is sought is of the nature of public office. Secondly, the appointment of the post must be found to be contrary to the statutory provision defining the eligibility of the. Thirdly, the order is an usurper without legal authority and is unqualified to man the post which is public office. Supreme Court in University of Mysore, C.D. Govindra Rao, AAR 65, 46, 19, highlighted about the kind and nature of the writ of Quarento the following. Broadly stated, Quarento proceeding affords a judicial inquiry in which any person holding an independent substantive public office or franchisee or liberty is called upon to show why, by what right he holds the said office, franchisee or liberty. If the inquiry leads to the finding that the holder of the office has no valid title, it issue the writ of Quarento and oust him from the office. In other words, the procedure for Quarento confers jurisdiction and authority on judiciary to control executive action in the matter of making the appointments to public offices against the relevant statutory provision. It also protects a citizen from being deprived of the public office. Now, my lord, this is the requirement, and this is exactly, my lord, they sought a selection matter, and they sought a writ of one.
We are not considering that.
Lordship. So, my lord, my humble submission, my lord, even the writ of Quarento is not lie in this case. So, unless he cross, my lord, the threshold, my lord your lordship will get into the marriage. But saying this, my lord, at the same time, my lord, is not that I will not make submission on the issues raised by him, my lord. It is there in my compilation, including the decision he has relied on, my lord. I'll answer them. I'll answer them, your lordships.
Yes, Mr. Day. My lord. You want me? No reply. Not necessary.
I will reply, my lord, definitely. I will reply. If my lord is finished, I can reply.
You finished? Mr. Sen,
This has to be annexed, yes.
any other submission?
Well, the submission on whatever he said on marriage, including
Yes,
constitution.
what about then the affected respondent? Not affected, I mean the
appointed respondent.
Yes.
I want to raise the question of utility.
Of course, I mean you have to address that also, since that's the question the court is addressing. I think we'll hear tomorrow. Yes, yes.
Yes. My lord, this if I am permitted, my lord, now I have got the correct decision, my lord, the wrong decision. And that has been set aside. Even then, that copy of the division bench also I will place to avoid any confusion, my lord.
Exactly, because
That has been set aside. That has been set aside. The correct one, my lord, if we lordship returns it, the correct one I will.
Two famous litigants, Dr. Professor
Manmohan Singh, yes.
If your lordship returns this, my lord, the correct one I will.
Those are practiced long enough, will know.
If my lord recollect, you sit in the last bench of the old High Court. And my lord has also argued probably for him.
Not for David Malone.
No, for Dr. Manmohan Singh.
Manmohan Singh, I wrote a judgment against him.
Oh,
in the division bench. Yes.
If your lordship return this, my lord, after corrected copy I will submit.
Yes.
That's the compilation by tomorrow.
So your juniors are sabotaging your case. Yes. Just for further arguments tomorrow. Tomorrow we'll hear Mr. Nongbri. Yes. And Mr. Shangreso also. Yes. Thursday. Biar apa yang macam? What we put on there?
26? 26?
Wait, please.
Yes.
The petitioner has been.
What is it for today?
So, hearing on the 711 application, Lordship.
Yes, you ready?
What has transpired in between is that my learned friend has filed a fresh affidavit in this matter, and I have been served with a copy.
When he filed
That was filed in December last year, Lordship. Yes. There was leave directed by the Honorable Court, Lordship.
What affidavit? When?
Lordship, this was order of 15/10/25, my lord.
You filed 8/12.
I filed it on 8/12, Lordship.
Since then, the matter has been adjourned at the request of the petitioner.
See, are you interested in pursuing it?
It has not been, Lordship, we have never adjourned the matter. They had filed the adjournment.
She kindly sees the last orders.
Last orders meaning? Seriously, you've taken a
It
job.
was last. Yes, madam.
So now election petitions, henceforth, if they have to be adjourned, we'll impose a cost of 10,000 per adjournment. Maybe then we can bring some closure to these matters. Yes.
More than 30 adjournments in this matter for the election petition.
Makes a mockery of election law. From 25/11 on behalf of election petitioner, then even 8/12 election petitioner.
To file it, Lordship, on the course of the. Thereafter, I have.
Then even 5/2/26 election petitioner.
Lordship.
The last order also.
So
only in 3/3/26 they've taken time.
Lordship. So I am ready for the hearing today.
So, Milord, as far as the issue in this matter is,
Where's the affidavit?
this matter is
It's a short affidavit, Lordship, just to clarify on that.
1 second. No, we have not seen this also. Oh yes.
well, in this case, the issue was that I was served with a copy of an election petition which was neither signed, stamped, notarized. And to let's get over that, this new affidavit has been filed based upon certain new averments which the election petitioner has introduced, my lords. So, my lords, just sees only one paragraph of this, although if paragraph H, my lords, at page
You mean
7.
to say that this also will lead to preliminary
Lordship, yes, because
preliminary issues being decided?
Lordship.
Because kindly
Only for
see
evidence.
paragraph H.
See, by the time that is done, with the adjournments you'll take will be like beyond 2028.
So I'm ready to have it on a day
Yes.
also, Lord.
See, the question of you wanting to have.
Lordship, I understand that. But this is the situation, my lord. That is why we were asked to file this affidavit to clarify it.
Because if I count the number of adjournments, it goes into Milord's 30, 40 adjournments by the petitioner itself. So there is no urgency by the petitioner in this matter, Milord. And he
How many times
admits in
have you
paragraph
adjourned
H-
the matter? How many times have the respondents adjourned the matter?
Milord, hardly it must be 4 or 5 times. Because it is going on since the last 3 years, Milords. But it is not, the adjournments have not been sought on the behalf of respondent in this matter, Milords. All because earlier some other counsel was engaged by the election petitioner.
That was the
and then,
difficulty,
Milords,
Lordship.
Oh, yes.
Counsel was
there
from
was no
Delhi. He
counsel
did not
in
appear
between.
for.
Now the only question that remains now whether the copy served on you
Was a true copy of
was a true copy of election petition presented before the registry.
Lordship, yes.
Correct.
Yes, Milord. So I'm just, Milords, if my learned friend has filed this affidavit, I may be given an opportunity, Milords, to respond to this because there are certain factual averments. To
Okay,
this.
1 week.
Yes, Milord.
Yeah, Mr. A.S. Pandey pays was allowed 1 week's time for objections to the affidavit filed by the, or reply to the affidavit filed by the election petitioner on
8/12, Lordship.
8/2025. You know what next order is coming then? If you're disputing the on the ground fact itself, then preliminary issues have to be framed and.
Yes, in fact,
no
he
other way.
says something in my favor because he admits that he has submitted a copy which is not signed in paragraph H.
Then you put on affidavit.
Yes, Manoj, I will put that on affidavit.
Yes.
Published.
Published.
27.
Yes.
May I please, Your Lordship?
What is,
Your Lordship, this is a part-heard matter. Your Lordship, the issue in this case is whether the petitioner who was appointed in 1998 and regularized in 2015 is entitled to avail pension under the old pension scheme by other situated staff who were appointed after him and regularized by the Cabinet Decision 2022, Your Lordship.
yes, Mr. Pillai.
May it please your Lordship. Lordship, kindly come to page 47 of the writ petition.
47.
Lordship, yes. He has been regularized with effect from
2015.
On 30th June 2015, your Lordship.
Yes.
And the date of and there is no retrospective operation, your Lordship, in that.
This was passed in terms of, you didn't challenge this one.
No,
No,
there
Your
was no
Lordship,
challenge,
we have submitted different representation, Your Lordship, several communication, but it was rejected, Your Lordship.
And this regularization, your Lordship, has been done in pursuance to the order passed by this court. If Lordship kindly turn to page 66. Lordship, the order passed by this honorable court, your Lordship, will find it at page. Lordship, kindly have page 33.
Page
33, your Lordship. This is the writ petition number 26 of 2013, wherein the petitioner has sought for regularization, your Lordship. So that order, your Lordship, that order regularizing the petitioner in the year 2015, your Lordship, has been done in compliance with the direction passed by this honorable court in the earlier writ petition of 26 of 2013, your Lordship.
The petitioner himself approached this court in the year 2013, Your Lordship, and there was an order in the year 2014 to regularize him, Your Lordship, to consider his regularization, and that has been exactly done by the government, Your Lordship.
Your Lordship, my case here is that other similarly situated staff.
That they are similar situations, or they are under different.
Those have been regularized by the cabinet, Your Lordship.
Just because they are regularized by the cabinet, Your Lordship, and just because I'm regularized by this honorable.
After 2015, orders past 14, you regularize. Where's the regularization order?
Lordship, at page 47, Your Lordship.
No, regularization order.
Of the petitioner, Your Lordship?
48, Your Lordship.
Yes, page 48.
48, Your Lordship. 47, Your Lordship. 47, 48, Your Lordship. Yes.
Your Lordship, it with regards to my pensionary benefits, Your Lordship. It's my pensionary benefits, Your Lordship.
And only, Your Lordship, when...
Your Lordship, several communication was made, Your Lordship.
That's what in 22, after the cabinet decision came out.
Yes, Your Lordship. On coming to learn about the cabinet decision, I've also submitted a representation, Your Lordship.
Sorry.
Your Lordship, I have numerous judgment, Your Lordship, supporting my case, Your Lordship.
Yours is a special case.
Your Lordship, on the last occasion, I've submitted this Rupak Chandra, Your Lordship.
Yes.
I would like to submit this to you. Your Lordship, in all these cases, Your Lordship, the period of officiating officiating period, Your Lordship, have been counted for pensionary benefits, and they were given pension under the old pension scheme, Your Lordship. In this Chandri Prasad, Your Lordship, the Delhi High Court, Your Lordship,
Which para?
has discussed several judgment of several High Courts, Your Lordship. The relevant paragraph is from 7, Your Lordship.
No, your case is a different footing. Why? Because he had come 2014 for this court asking for
Regularization.
for your service, for the services that you rendered, right?
Yes, Your Lordship.
15 years. So this court said, fine, consider you to raise you in your post. Then they passed an order in 2015 itself that this should be with effect from so and so. But that time 15, it's over. You are regularized, you're happy. Now after 22.
We are not happy, Your Lordship. We have sent several representatives, Your Lordship. Yes, Your
You're
Lordship.
not challenged it in court.
But we're waiting for the response from the respondent, Your Lordship.
You could come to the court, the first instance seeking regularization. You would have jolly well come also after you feel that you should have been given from the date of initial appointment.
Yes, Your Lordship.
Your case on different footing. These other people just that they were working temporarily, then they were regularized subsequently, so they want the dates to be counted from the date of first appointment. Your case that it came by a court order, you regularized, order was passed with effect from so and so, very clearly written, you accepted that. Now after the 22 cabinet decision came, where people upon 2007 were given regularization,
but Your Lordship,
and benefits the old pension scheme, which is a policy decision.
Yes, Your Lordship, but juniors to me, Your Lordship, who was appointed
doesn't
after
matter.
me. Your Lordship, there has been, if I may take Your Lordship to page 50, Your Lordship, of my writ petition.
We have filed affidavit.
Lordship, yes, we have filed.
Yes, page 50.
Your Lordship, if had the respondent, Your Lordship, submit my name for consideration, Your Lordship, in the year 2006, Your Lordship, my name would have been forwarded for regularization, and I would have fallen under the...
sympathy is there for you, but technically...
But the delay on the part of the respondent, I cannot be attributed to me.
Now 2018. Yes, Mr. Shulai, where's your affidavit?
Lordship, in fact, they are sitting in the fence. He's sitting in the fence, Your Lordship. Lordship, kindly have...
2018, they filed representation also.
there is a... First, Your Lordship, there is the delay.
The regularization has been done in the year 2015, Lordship, as I have submitted, Your Lordship. They filed the writ petition 2024. Lordship, then Lordship kindly have page 19 of the affidavit. That is the order passed by the Honorable High Court, Your Lordship. Our Lordship will kindly come to page 22.
You already, this order is already there.
Lordship, yes. Then Lordship, I came the order at page 23 in pursuance to the order at page 24, Your Lordship.
That's already there in
Lordship, yes.
In a repetition, yes. What are we going to show?
The other people who have been regularized, Lordship, in the year 2022, these have been done by the cabinet, Your Lordship. But in the case of the petitioner, it is a court ordered regularization, Your Lordship. And the government has taken a conscious
Where is the
decision.
earlier petition? The copy is here.
No, Your Lordship. Your Lordship, if
You
I
just
may.
bring it. We'll see what Prey made there.
Okay,
So, can reach no date of appointment or from. You just bring
Your
it.
Lordship, if I may take Your
Take
Lordship
out
to page 76, Your Lordship.
Yes.
If I may take Your Lordship to page 75, Your Lordship,
Of the petition.
of my repetition.
We won't close it here. I just. want
That
to
is
see your
completely a different thing, Your Lordship.
Page 70.
5.
This is
No, Mr. Shulai.
Lordship, I'm sorry, Lordship.
But this we've seen. This is the old hat.
But Your Lordship, in point 6.
Just one thing. In the course of hearing, it is noted that the records of WPC number 26
Of 2013, Your Lordship.
13 are required for adjudication in this matter. Accordingly, recruitment is list on when? After 1 week.
2 weeks, Your Lordship. In case I don't have the copy, I may apply. I may be allowed to apply for.
Copy. We'll look at it together.
Okay.
Save us the trouble of applying copy. If you made the prayer only for a regularization or a retrospective, then
apply, Your Lordship.
Highly applied.
28.
Yes.
This is the case. In fact, I have concluded my part. This is regarding my lord promotion based on seniority come merit in district council, and I have submitted my compilation also.
Forgotten
In view of the change of the council, I don't know, my lord.
Mr. Khilap appearing with this council now.
Yes, I am appearing for district council. Respondent number 1 to 4.
Ready to matter today, Mr. Khilap?
No, I am not ready, Your Lordship. Maybe 10 days time.
Okay, Mr. Roddy Khilap submitted has just been newly engaged on behalf of the respondents number 1 and
1 to 4.
1 to 4.
Yeah.
The pre-response allowed 3 weeks time to prepare the matter.
Oblige.
31.
Lordship, this matter also kindly, after 2 weeks, Lordship, just on behalf of PS Nongri for today, Lordship. Personally.
Who was handling before?
This again, senior year.
My lord, 4 weeks, my lord.
4 weeks?
My lord, they seem to not have their offices in order. It will take some time.
Okay. The parties pay the matter within 4 weeks. And just pay is allowed. Yes.
Oblige, my lord.
Lordship.
32.
Shreya Gupta, yes. Yes, MSD Cruz.
May it please your lordships. Lordships, this matter is regarding the transgender reservation in the Indian Institute of Management. My lords, I'll have to...
affidavit, they file affidavit, Dr.
Lordship.
Mazika?
Yes, Lordship. Long time. We've also filed a rejoinder, Lordship.
Only filed rejoinder.
Yes, Lordship. Lordship, there's a matter pending in the Supreme Court that may have a bearing in the current litigation, Lordships, before you. Before this.
No, but one thing you have to see, if they have they have not implemented the reservation now, so
Lordship.
how can it be accommodated?
Lordships, Lordships may come to the Indian Institute of Management Act of 2017. I'll just provide a copy, my lord.
When's the matter listed in Supreme Court?
My lords, I don't have the next date, but
Yes,
it's
what
currently pending.
section they're referring to?
My lords may come to the provisor to paragraph to section 8.
Proviso to section 8, yes. There are two provisos.
Lordships, the first proviso, Lordship.
Yes.
provided that nothing in this section shall be deemed to prevent the Institute from making special provisions for the employment or admission of women, persons with disabilities, or for persons belonging to any socially and educationally backward classes of citizens, and in particular for the scheduled castes and the scheduled tribes. My lords, if I may take you to the relevant portion of the directions in NALSA judgment, where the Supreme Court has categorically directed to treat the transgender persons as socially as well as educationally backward classes, and further directing the center as well as the states to extend all kinds of reservations in terms of
which para is that?
My lords may come to para 135.3. 135.3.
135.3, yes.
My lords.
Yes.
My lords, in terms of this particular direction.
But that is the thing, that we all know about the judgment, but they have not implemented any policy or made any provisions in their respective statutes to accommodate such a category of such a person.
My lords, but
then we'll wait. We'll adjourn it.
But otherwise, this has become only academic now, my lord.
It's academic, but then
one semester is over, my lord. One semester is gone now since September.
No, it's academic, no doubt. But then
well, this would be the larger issue.
Imprint.
My lord, next year will be next scene, my lord. They have to appear.
Next year, but are you going to make provisions?
No, my lord, they have to appear again for.
No. Are you going to make provisions for LGBTQ, reservation in AIM or in others? Which other central institute has reservations?
None, my lord.
My lords, there have been states. There are states
said in our
institutions.
affidavit, Lord, so kindly see few lines.
And let us adjourn it. Let us wait. Let's see if that it comes from the Supreme Court, then we are bound. Yes, MSD to submit that as a matter in the same issue pending for the Honorable Supreme Court. It might be adjourned for 6 weeks to await any outcome.
Highly obliged, Lords.
33.
Certainly. Yes.
Lordship, this instant petition is filed for challenging the impute order dated 26.
Come first time for hearing.
First time,
first time,
your lord.
Yes, Lordship.
You ready? Why?
Lordship, I am proposing since they are buying for the post and all, let a new and fresh election be held, Lordship. Let them have a level playing field, your Lordship.
Fresh elections. Yes, Mr. Indishula has AAG has submitted that if the contesting respondents are agreeable, perhaps fresh elections can be called for.
Yes.
MS ML Clown, we have a petitioner, and Ms. S. Hassan for respondent number
8, 9, and 10.
To obtain instruction. It's up to 2 weeks. You obtain instruction, you're ready for fresh election. You want that, correct?
Yes, Lordship.
Yes.
Earlier they won, and then later on they won, Lordship. Now let them have. Apply.
1.5.